removal from office as Deputy President by impeachment be halted until the determination of this petition. The petition further seeks a conservatory order restraining the Senate from admitting, processing, debating, or in any other manner whatsoever considering the motion for proposed removal of the petitioner as Deputy President from office by impeachment, founded on the motion passed by the National Assembly until the hearing and determination of the petition. The petitioner also seeks a certification that the petition be satisfied as raising questions of great general public interest and should be placed before the Honorable Chief Justice for impaneling a bench of an infinite number of judges to hear and determine the petition. The petition and motion are brought under articles of the Constitution and also the High Court and Organization and Administration Act, as well as the Mutunga rules. The petition and motion are based also on the petitioner's affidavit and supplementary affidavit, annexures and written submissions. The motion is predicted on the grounds that this court has jurisdiction and Article 23 of the Constitution to consider an issue and give remedies, including a conservatory order in appropriate and deserving cases. The petition states that a motion dated 26th of September 2024 was tabled in the National Assembly on 1st of October, proposing his removal from office as Deputy President of the Republic by impeachment. The National Assembly allowed the motion on 8th of October 2024 at 9 p.m. On the same night, the Clerk of the National Assembly transmitted the resolution to the Clerk of the Senate. The petitioner states that the resolution passed by the National Assembly is invalid on several grounds. These include that the impeachment motion is replete with general and supported allegations, hearsay, and outright lies without particularization and specificity as required by Article 145, Sub-Article 1 of the Constitution and Standing Order number 64 of the National Assembly Standing Orders. The petition further states that the National Assembly did not conduct a constitutionally compliant public participation prior to passing the impeachment motion, and the impeachment motion did not also meet the threshold in Article 145, Sub-Article 1, among other grounds. The petitioner asserts that in Gazette Notice number 13-170 of 9th October 2024, the Speaker of the Senate convened the Senate to hear charges on the proposed removal from office by impeachment. Subsequently, the Speaker of the Senate issued another communication the same 9th of October 2024, directing on how the proceedings will be conducted in the Senate. It is the petitioner's case that, unlike the respondent who will not suffer prejudice if conservative orders are granted, he risks losing his position of being disqualified from holding any state and public office by virtue of Article 75, Sub-Article 3 of the Constitution. The petition argues that the substratum of the petition will also be lost and rendered moot if conservatory orders are not granted. The first respondent has responded to this petition through grounds of opposition, raising some of the issues, including that this court has no jurisdiction to hear this matter because there is another petition which makes this one sub judice, and that is petition 522 of 2024 that was heard, I believe, by my colleague. The respondent states that the application and petition amount to forum shopping, are an abuse of the court process. The respondent further states that under Article 165.3c, this court lacks jurisdiction to determine the removal of the Deputy President by way of impeachment under Article 150 of the Constitution. According to the first respondent, the court cannot consider the legality or constitutionality of the impeachment motion against the petitioner and of public participation, because the motion is yet to be fully considered by Parliament and public participation is yet to be completed. This, the first respondent argues, renders the petition non-justiciable. The petition is also offends the doctrine of what he calls committee, judicial restraint, separation of powers, among others. The first respondent again states that the impeachment of the Deputy President is conducted in time-bound proceedings, and therefore this court cannot issue a conservatory order during active parliamentary proceedings, including the ongoing impeachment. The first respondent maintains that the petition violated settled law by the Supreme Court in the Wambura and the Mate case. The second respondent also opposes the petition through a replying affidavit. The second respondent states that the Constitution and the National Assembly standing orders provide comprehensive and time-specific legal framework for removal of the Deputy President by impeachment. The process was followed, public participation conducted, and the petitioner was afforded a hearing. The resolution to approve the impeachment motion was therefore valid and in accordance with the Constitution. According to the second respondent, the timeline for processing impeachment both in the National Assembly and Senate are provided for in the Constitution, namely Article 145 as read with Article 150 of the Constitution. The second respondent maintains, therefore, that public participation was also conducted after publishing the notice inviting members of the public to attend and give their views on 3rd of October 2024, and then the exercise was subsequently extended to 4th of October 2024 as directed by the High Court sitting in Kerugoya. The processes be conducted in the constituencies. The second respondent asserts, therefore, that the petitioner was given a hearing in compliance with Article 47 and 50 of the Constitution and attended the debate in the National Assembly on 8th of October. Thereafter, members of the National Assembly took a vote and the motion was passed. On 9th of October 2024, the Speaker of the National Assembly notified the Speaker of the Senate as required by Article 150 sub-Article 2A as read with Article 145 2A. Thus, the National Assembly followed the Constitution and the law on impeachment of the petitioner. The third and fourth respondents also opposed the petition and application through a preliminary objection that this court has no jurisdiction to hear this petition. Many of their arguments actually mirror what the other respondents have argued. On the submissions, during the hearing of the application for conservatory orders, counsel for the parties made oral arguments highlighting their respective positions over the matter. For the petitioners, Mr. Paul Muite, Senior Counsel, teaming up with Mr. Macharia, Mr. Ongoya, Ms. Waigwa, I hope I got the names right, and Mr. Njomo, have urged the court to grant conservatory orders. Senior Counsel put the record straight that the petition is not a forum shopping, as the respondents have argued in their responses. Senior Counsel maintains that a new cause of action arose after the National Assembly passed a resolution on impeachment motion. This was a new development that necessitated filing of this petition. Regarding the impeachment of the President or Deputy President, Mr. Muite argues that it is a two-phase process. The first phase is in the National Assembly and the second phase in the Senate. The resolution in the National Assembly gave the court jurisdiction to do justice to the matter of impeachment of the Deputy President. According to Senior Counsel, when the people of Kenya enacted the Constitution, they gave this court jurisdiction to hear and determine anything said to be done in accordance with the Constitution. Senior Counsel asserts that Article 23 requires the court to uphold the Bill of Rights, an authority conferred on this court, while Article 23.3 gives the court power to grant conservatory orders in appropriate cases. According to Senior Counsel, Article 25C is clear that the right to a fair hearing / trial cannot be limited. He maintains that the petitioner's right to a fair hearing has been violated, that public participation was not properly conducted, as the Supreme Court directed in the British American tobacco case, that this court has jurisdiction to investigate the matter since the National Assembly acted as a quasi-judicial body. In the Council's view, the 12 days provided for in Standing Order number 64 of the National Assembly Standing Orders violates Article 50, Sub-Article 1 of the Constitution. Further, public participation was to take place at county headquarters until the High Court at Kerugoya directed that public participation be conducted at constituency level. The notice to that effect was issued late, and according to Council, that explains why the turnout was a paltry 224,000 people who took part during the exercise. Public participation was not therefore meaningful and did not comply with Article 118 of the Constitution. Mr. Muite, Senior Counsel, again cited the decision in Kitaru Peter Munya and the bundle of their documents on the public as that public interest in constitutional and the constitutional values is the basis for granting a conservatory order. The resolution was transmitted to the Senate immediately, and immediately after the Senate set the process for trial in motion, posing the question, why the haste? Senior Counsel again cites the decision in Joseph Enoch Aura on the minimum requirement for effective and meaningful public participation and urges the court to grant a conservatory order. Mr. Macharia, who took up after, argued that the court has jurisdiction, that the matter is not sub judice, and that the decision in Wambora case is distinguishable from the present petition, since in that case conservatory orders were issued in the middle of proceedings in the county assembly. In this case, he argues, the process concluded in the National Assembly, a fact that was also admitted by the Respondents' Council during the hearing of petition number E522 of 2024 before Mugambi J. On sub judice, Council argued that under the Mutunga rules, a party can approach the court in any manner and the court will have to hear him. On ripeness, he urges that there are exceptions and relied on a U.S. decision that support the argument that where something is to happen, one does not have to wait until it happens so that there is ripeness. For the second respondent, Mr. Nyamodi, teaming up with Mr. Kipkogei Wanyama, I hope I got the appearances right, and Mr. Mwangi have argued that the petitioner is guilty of firearm shopping. They make reference to petition E522 and the prayers in that petition, which are said to be identical to those in the present motion. He also refers to paragraph 6 of the ruling in that matter, maintaining that the same arguments made before Mugambi J have also been made in this court. Mr. Nyamodi further argues that the National Assembly passed a resolution on 8th of October 2024, and the parties appeared before Mugambi J on 9th of October 2024, and the ruling was delivered on 11th of October 2024. It was the petitioner's duty to press that court to grant conservatory orders in that matter, the council argued. The filing of this petition amounted to forum shopping. Regarding the matter before the Senate, Mr. Nyamodi maintains that the process based on a constitutional timelines, that the court should allow the process to go on. Regarding public participation, council argues that it is not a must that every person takes part. If the attendance was to be taken into account, elections would be challenged on very many grounds, including that of poor attendance during elections. It was the council's view that Article 145 has a threshold with regard to numbers in the National Assembly and the Senate. Mr. Gumbo, who takes over, adds that once the process is concluded in the National Assembly, Article 145C kicked in, and the Senate took over and has scheduled a hearing. The court should exercise deference and restraint And once concluded, the court can then interrogate whether anything said to have been done is constitutional. Council cites some decisions, including the one of Sonko, Mate, among others, to support their position. He argues that the petition will not suffer any prejudice if conservatory orders are not granted, as Article 145, Sub-Article 5 gives a safety valve for him to appear before the Senate. Mr. Wanyama then takes over and adds that the petitioner is precluded from raising issues that were in petition E522. He argues that the petitioner's counsel informed Mugambi J that they were not pursuing the order for conservatory orders at that time. The proceedings before the National Assembly had concluded, and counsel for the petitioner did not want them to respond to the order for seeking conservatory orders. That was why the court, that's Mugambi J, did not deal with the issue, or only dealt with the issue of certification. Mr. Wanyama cited decisions, including Peter Munya and others, as the test for granting conservatory orders. He cited the decision in Julius Kariuki Mate also, and in his view, the Constitution provides for timelines which should be respected. On public participation, counsel argued that this being a constitutional imperative, it should be done within certain timelines, and the court should not therefore issue conservatory orders that may destabilize the process. Ms. Tanje, who appeared for the third and fourth respondent, reiterates the other respondents' positions that the court has no jurisdiction to hear the matter at this stage, and place reliance on the decision from the Court of Appeal in the Mwangaza case that the court has no jurisdiction at this interim stage. Counsel again relied on the decision of Kariuki Mate and Honorable Nyaga to argue that the petition will not be rendered nugatory, as the petitioner will have an opportunity to come to court after the process is concluded. Further reliance was also placed on the case of Sonko. The first respondent, Mr. Milimo, chose to respond last and reiterated more or less the arguments by counsel for the other respondent. Mr. Milimo emphasized that this application seeks similar orders that were sought in petition 522 of 2024, that the petitioner has not disclosed the existence of that petition 522, and that this matter is therefore sub judice, and relied on Section 6 of the Civil Procedure Act to support this argument. Regarding the fair hearing, Mr. Milimo argued that the petitioner will be given an opportunity to appear before the Senate, and relies on Mwangi Wairia case versus the Speaker of Murang'a County Assembly, that a person facing impeachment should not shy away from constitutional processes. In a rejoinder, Mr. Macharia argues that the petition is not a forum shopping. The petitioner only seeks order number 4 in his application, and that the statistics like the ones from Keyo constituency was not an issue in petition 522, so that this makes this petition different. Having considered the arguments by parties and the decisions relied on, I have distilled 2 questions for determination. These are whether this court has jurisdiction to hear this matter, and whether conservatory order should be granted. The respondents argue that this court has no jurisdiction, as this matter is a constitutional process under Article 145 and read with 150 of the Constitution. Some of the respondents have gone further as far as arguing that Article 165 sub-Article 3C osts this court's jurisdiction from hearing disputes arising from impeachment of the President and the Deputy President. They also argue that this matter is sub judice, since the orders sought in the application were also sought in petition E522 of 2024. There is no dispute on what jurisdiction is. It is the authority given to a court to hear and determine disputes before it. Jurisdiction of a court may be granted by the Constitution, statute, or both. Any time the jurisdiction of a court is challenged, it is a threshold question which the court has to examine and determine. Should the court determine that it has no jurisdiction to hear matter, that is the end. The court should not take any further steps. It must down its rules. Those are the famous words of Nyarangi in Honors of Motor Vessel. Addressing the issue of jurisdiction in Samuel Kamau Macharia, the Supreme Court did state the jurisdiction of a court flows from either the Constitution or legislation or both. Thus, a court of law can only exercise jurisdiction conferred by the Constitution or the written law. It cannot take other steps to bring life in those disputes. The court, having not dealt with the issue of conservative orders in that matter, I say no more on that issue. The issue next is whether this court should grant his right to a fair hearing, and that